Dear civil service aspirants of our nation, I hope you are steadily moving forward with your preparation for the civil services exam. We will take 10 more questions in this video to learn some more dimensions of polity. My sincere advice is that you keep the Constitution of India handy and refer to it when required. Those of you who are directly and only watching this video may like to pause after seeing the question, attempt it first, and then proceed to hear the brief explanation. Or the best would be to attempt the question first on the WhatsApp and Telegram channels and then learn more from these videos. As always, we will also try to learn something more than the question on the screen through images. Like what you see on the screen here is the Parliament of India. In the front is the new building which was inaugurated in 2023. And also at the back is visible the old building, which is now a museum. In the next 10 slides, you will see some person who was behind some landmark cases in the Supreme Court that changed the Indian life. See if you can recognize these individuals and use the opportunity to quickly recall and revise the case in point. This is definitely not an exhaustive list and only some of the many such individuals. Right, so let's take the first question, which says the Constitution of India guarantees freedom of thought and expression to all citizens subject to, which basically is giving the idea that there are certain limitations that can be imposed on freedom of thought and expression. And we know that is under Article 19 of the Constitution, the freedom of thought is given. And first says implementation of some of the directive principles of state policy. Now, this is where comes the Minerva Mills case. We all know Minerva Mills versus the Union of India, 1980, where the court held that the balance between Part 3 of the Constitution and Part 4 of the Constitution is part of basic structure of the Constitution of India. That is, even though DPSPs are not enforceable, sometimes the laws made to implement the directive principles sometimes the laws made to implement the directive principles, they can override some of the fundamental rights. Some DPSPs can override some fundamental rights, not all. More specifically, in this case, they upheld Article 31C of the Constitution, which was introduced by the 25th Amendment of the Constitution in 1971. According to that, and I'll just bring it up for you, if you see 39 clause B and 39 clause C, where it says ownership and control of the material resources of the community are distributed to subserve the common good, and the operation of economic system does not result in the concentration of wealth and means of production to the common detriment. So this was actually in the background of the bank nationalization that 25th Amendment was made, and we said that if we make these kind of laws, and this results in the violation of Article 14 and Article 19, it is okay. That means to implement some of the DPSPs. Which of the DPSPs? We know 39 clause B and 39 clause C. They can act as a restriction to the freedom of thought and expression, and also equality in Article 14. So the first option is correct option. Now, second says fundamental duties. There is no limitation from fundamental duties, at least not in our jurisprudence so far. So the correct answer of this question is only one. And hardly 20% of the people out of about 9,000 who have attempted it on Telegram channel could get it right. Nevertheless, next question is, by the way, this is Mr. Raj Narayan, a very popular personality. Many cases are because of him, especially against Madam Indira Gandhi. He was also a candidate from Rai Bareli. So I thought you should know what he looked like, at least. Anyway, so which of the following are envisaged under the right against exploitation in the Constitution of India? Now, right against exploitation is Article 23 and Article 24 of the Constitution. Okay, so Article 23 prohibits human trafficking and forced labor, so that is definitely there. Then Article 24, it prohibits employment of children in the factories and mines and hazardous employment. So third option is also correct. Now the second one here, the abolition of untouchability. This is provided under Article 17 of the Constitution, which is part of equality. Right? Article 14 to 18 is right to equality. Though one may think untouchability is also exploitation, however, it is not exploitation per se. It is unequal and unfair treatment and may be a reason behind somebody's exploitation. So, correct answer here should be 1 and 3 only. Moving on, DPSPs in the Constitution are limitation upon legislative function, executive function. Now, DPSPs are not a limitation on anything. Firstly, we all know that directive principles are not enforceable in the court of law. So, anyway, nobody can use them as an argument to get a direction for either the legislature or the executive. These directives, they can exist in the constitution without affecting anyone. They have moral value, persuasive value. However, no limitation is imposed by them. Hence, neither one nor two. There's no limitation caused by DPSPs. And I hope you recognize the lady here by now. And if not, here is a hint. Yes, that's Menaka Gandhi. This case of 1978 is a landmark case where Supreme Court held that Constitution of India provides for due process of law and a law has to be fair, just and reasonable, and also that Article 14, 19 and 21 they form a golden triangle. Then in the next question, which of the following is are not necessarily the consequence of a proclamation of president's rule in the state? Now, president rule is Article 356 of the Constitution. And by the name itself and the very definition of it, president rule is taking over the state's administration by the president. That is the central government. So the president dismisses the council of ministers. President can also suspend the assembly, right? President can suspend the assembly, but they cannot dissolve the assembly unless the parliament has approved the proclamation. This was also the judgment of Supreme Court in SR Bommai case of 1994. SR Bommai case 1994. So dissolving the assembly is an optional power. Okay, it's not an automatic. It's not a necessary consequence. It's not an automatic consequence. It is an optional power which is also exercised after the approval by Parliament. For example, since February 2025 till February 2026, earlier this year, Manipur was under President's rule. Manipur was under President's rule. Oh, I lost that. Anyway, so when the president rule was finally removed, a council of minister could be created. Why? Because Manipur was assembly was not dissolved. Had it been dissolved, we would not be able to do that, and we would have had to conduct the assembly elections there. So this is the reason why sometimes they don't do that. So anyway, which is not a necessary consequence of the proclamation is dissolution of the state's legislative assembly. The only thing that is guaranteed will happen is suspension. Dissolution may happen with the approval. Anyway, and that's Shah Banu Begum, very important case. Please make sure you know that. Then it is the duty of the C&AG of India to audit all transactions related to Consolidated Fund of India, of State, Contingency Fund of India, Public Account of India. See, the C&AG of India audits all the accounts of the government of the union and states, right? So not only the three funds of the union and the state, and the public account of India, even the public account of the state, the contingency fund of the state, everything, all transactions that take place for the government, they're all audited. So anyway, all of these is the correct answer. I would have hoped higher percentage of people to get it right because this was actually a straightforward question. But nevertheless, let's move on to the next question. And it says the reports of the C&AG of India related to the union government accounts. First option says are submitted to the President of India, can be considered in the joint session, and are the basis of scrutiny by the Public Accounts Committee, the PAC. Now, see, the first option is a straight picked up point from Article 151, where it says the reports of the CAG of India shall be submitted to the President, who shall cause them to be laid before each houses of the Parliament. Right, so that's a very correct point. Then second one says that can be considered in the joint session. Firstly, there is nothing called a joint session. ऐसा कुछ होता ही नहीं है. What we have is a joint sitting under Article 108, joint sitting, which is for resolving deadlock on bills. There is no other purpose of joint sitting. So discussing or CAG report, etc., it's a meaningless statement. Second is wrong. Then third says that the basis of scrutiny of Public Account Committee of the Parliament. This is precisely what is the role of CAG in India, and hence CAG is also referred as the friend, philosopher, and guide for the Public Accounts Committee. So here, only the first and the third statements are actually correct. And you may not have recognized that's Madam Olga Tillis, the journalist who led to this famous case. But you should be able to recall the significance of this case. Supreme Court held that right to livelihood is a part of right to life under Article 21. Then the speaker can ask a member of the House to stop speaking and let another member speak. This phenomena is known as, first option says decorum. See, decorum is, as simple English also, to maintain polite, courteous, and parliamentary behavior. This has got nothing to do with what the question is asking. Then crossing the floor. This idea is to pass between, when any member passes between a member who is addressing the House and the chair. So if somebody crosses the floor, this is considered breach of parliamentary etiquette. So this is also not what we're talking about. Now, interpellation. This is the right of the members of the House to ask questions on matters of public interest to the government. This is not a term mentioned in the rules, actually, but it's only a political term simply for questions, such as during the question hour, 0 hour, short notices, half an hour discussions, and so on. Interpellation is just a general political term for questions. So this is also not what we are talking about. So already the answer is clear. It is yielding the floor. And what does that mean? To stop speaking and let another member speak. So this member who's speaking right now, they have to stop. So when they stop, only then some other member can speak. So this is what is called yielding the floor, like giving away the floor. So the correct answer is D. And here too, you may not have recognized that is S.R. Bommai. Behind the landmark case of what I told you earlier, S.R. Bommai versus Union of India, 1994, which laid down various guidelines for the use of President's rule under Article 356. And it also declared federalism as a part of basic structure of the Constitution of India. Then, voting for election to which of the following offices is or are to be conducted with secrecy. First says Speaker of Lok Sabha. Now, technically speaking, there is no election of the Speaker actually. Constitution under Article 93 requires the House to choose. It doesn't say elect, but I mean, that's being technical about it. House to choose one member as the Speaker. So, yes, there is voting in the House on the motion proposing a name, and the motion made by the ruling party will logically get adopted by a voice vote. The nomination made by the opposition or other parties, if any, does not get taken up only for this reason. So whatever the ruling party proposes, they are now declared as the speaker. Anyway, that's the process that happens. Anyway, second one says members of Rajya Sabha. Since the 2003 amendment of Representation of People's Act 1951, the election is now open ballot for Rajya Sabha, where one member of the concerned party is allowed to see the vote by the MLAs of that party. This change was brought because corruption was undermining the fairness of the proportional representation system. And if you have been reading the newspapers carefully, recently when the Rajya Sabha election took place in Haryana, some party, they found their members were voting, cross voting as it said. So they took disciplinary action against them. Anyway, so that is open ballot. Then third one says members of a state's legislative council. Now this is definitely by secret ballot. So, Speaker of Lok Sabha, technically there is no election, but even when that happens, there is a voting inside the House, and inside the House it is open ballot. So that's not correct. Members of Rajya Sabha is also open ballot, not correct. Members of State Legislative Council, they are elected by secret ballot. So basically, amongst the houses, Lok Sabha, Rajya Sabha, Assembly, and Council, it is only the Rajya Sabha where the election is open ballot. Otherwise, everywhere else it is secret ballot. So the correct answer is only the third one here. So let's move forward to the next question. which says how can a legislative council be created or abolished in a state of India. Now, the relevant article of the Constitution is Article 169, where it says that Parliament may, by law, provide for the abolition of the Legislative Council of a state, or if there is no such council, to create such a council if the Legislative Assembly of the state passes a resolution by a majority of the total membership of the assembly and by a majority of not less than two-thirds. That's kind of a special majority. So the special majority is required in the Legislative Assembly of the state, and after that the Parliament makes a law. So obviously when the Parliament makes a law, that will be an ordinary law. That means by simple majority it will be done. So this is how it takes place. So anyway, the correct answer will be by Parliament by law. The other options don't fit because there's no meaning of Constitutional Amendment Act, and by Legislative Assembly of the state by resolution. There's no resolution, and a state doesn't have to make a law, and the resolution of the state alone cannot do that. After the resolution of the state assembly, Parliament has to pass the law also. A is the correct answer. And last question for this video, the matters related to the annual budget of the Election Commission of India are handled by which of the following ministries? Now, the correct answer is Ministry of Law and Justice, which only 12% of nearly 8,000 attempts on Telegram got it right. And I saw that 60% got caught in option 4, that it is an independent body. I created that option just to highlight that see, all such independent bodies also have a budget, which is often included under the grant of a ministry. For example, it is not only the Election Commission of India, even the Supreme Court of India, which is, we all know, is charged expenditure, all the expendices of the Supreme Court judges, right? Their salary, office expenditure, pension, everything is charged. But even that charged expenditure forms part of the budget. There will be a corresponding grant for that. That grant and also the grant for Election Commission, they are both handled by the Ministry of Law and Justice itself. On that note, that is all for today. And I'll see you again with the 10 more questions. Until then, study well, take care, all the best.